Can the Democrats in Congress impeach President Trump? Should Congress impeach Trump? Is impeachment a constitutionally provided safety valve or a political weapon to remove a constitutionally elected president? Welcome to DUFFLAW Digital, the YouTube channel of the Duffy Law Firm. My name is Brian Duffy, and I'm a Florida lawyer. In the next few minutes, we'll find out how a lawyer would answer these questions. Recently, many people in our country are arguing about the ideas of impeachment. Trump foes say impeachment is a tool provided by our Constitution, and the actions of President Trump are a proper basis for its use. Trump supporters say that never-Trumpers are twisting and subverting the impeachment clause in order to overturn a democratic election of a president. Some Trump opponents cite President Trump's firing of former FBI Director James Comey as an act of obstruction of the investigation into Russian interference with our most recent presidential election, and on that basis, these Trump foes claim Mr. Trump breached his oath to uphold the laws of the United States and that such action constitutes a high crime and misdemeanor as provided for in the Bill of Rights and the Constitution. So, are they both correct? Trump defenders maintain that the president has every right to fire a subordinate officer, such as a director of the FBI, and they even quote former Director Comey's statement to that effect. These Trump defenders even point to the fact that the investigation continued, despite Comey's removal, as evidence that the firing was not an act of obstruction of justice. Some Trump critics say impeachment may be used to get rid of a president who is, in their view, incompetent. So who's right? So what is impeachment all about? Is it a purely political process that can be brought forward by political opponents of a president? Or is it a legal process that should only be wielded in the event of serious, perhaps treasonous or criminal acts by the president or another federal officer, like a judge? In order to get our answer, we're going to apply our analytical lawyer skills, and we're going to think like a lawyer and see where the answer comes out. First, we start with a review of the primary source of the law. Here, we look to the U.S. Constitution and the Bill of Rights, which provide the legal and constitutional basis for impeachment. Article 2, Section 4 provides very succinctly, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. So the first step in thinking like a lawyer, look at the law, read the words, and see if you can obtain a clear answer from the law. It'd be pretty straightforward if the Trump opponents could show evidence or proof of treason or bribery. But what exactly does the Constitution mean when it says other high crimes and misdemeanors? If we see ambiguity in the Constitution as to what the words mean, we next look at case law, decisions from the courts, in order to understand exactly what is meant by other high crimes and misdemeanors. In this case, we look at the historical impeachment process by Congress. As it turns out, the impeachment clause of the Constitution has only been used against 3 presidents. So these are the cases that we look for. The first president to be impeached was Andrew Johnson. Johnson was selected as vice president by Abraham Lincoln, a Republican, as the only senator, and Johnson was a Democrat from a southern state that remained loyal to the Union. Lincoln thought Johnson would bring him support from Southern Democrats. After Lincoln was assassinated, Johnson became president, and Congress, consisting mostly of Republicans, politically opposed Johnson, especially on issues related to post-Civil War and Reconstruction. Congress passed a law that prohibited Johnson from firing members of his cabinet called the Tenure of Office Act. Johnson believed that was unconstitutional, and because we have 3 co-equal branches of government, the president, the legislature, and the judicial. So he fired his Secretary of War without approval from the Senate, and Congress moved to impeach him. After the impeachment by the House, the Senate held a trial. The Senate failed to convict President Johnson by 1 vote. Many commentators and historians believe the Tenure of Office Act was itself unconstitutional. Congress blocked President Johnson's attempt to have it reviewed by the Supreme Court. However, in 1992, the U.S. Supreme Court ruled the President had the authority to fire members of the Cabinet without prior consultation or approval by Congress, and the Tenure of Office Act was unconstitutional. Thus, most legal commentators believe the basis for impeachment did not rise to the level of high crime and misdemeanor. In any event, he was not convicted. Richard Nixon resigned before being impeached. Although there is some disagreement among historians and commentators, many believe that President Nixon's knowledge of the illegal Watergate break-in and evidence of his willingness to cover up that crime would have satisfied the constitutional requirement of other high crimes and misdemeanor. Since Nixon resigned, we'll never know. President Clinton was impeached on December 19, 1998. The two articles of impeachment were for high crimes and misdemeanors, specifically lying under oath and obstruction of justice. The Senate failed to convict President Clinton on either of the two charges, and he was acquitted because the Senate could not achieve a two-thirds majority of the vote. So the primary source of the law, the words of the Constitution in Article 2, Section 4, may not provide total clarity as to what exactly is meant by high crime and misdemeanors. The examples of Clinton, Johnson, and Nixon don't add much to our understanding. So next we turn to secondary source materials. Secondary source for legal research include things like legal encyclopedia, law reports, law journals, and often when we're trying to understand the law or statute, we look at committee notes or other contemporaneous writings at the time the legislation was drafted. For the U.S. Constitution and the Bill of Rights, we often turn to the Federalist Papers. These were writings by Alexander Hamilton, James Madison, and John Jay, a collection of articles published around 1787. They were intended to explain the new Constitution and gain support for ratification. It's obvious from the Federalist Papers and other contemporary writings that in the debates and the discussions of the framers of our Constitution, they were well aware of the traditions of English law with regard to impeachment and the use of other high crimes and misdemeanors. Some people argue that other high crimes and misdemeanors means only criminal acts could constitute a basis for impeachment. Many legal scholars say that makes little sense because if that were the case, the phrase and other high crimes and misdemeanors could have been more simply stated, and other crimes. Also, legal scholars point out that at the time of the drafting of the Constitution, there were very few federal crimes, and thus, if impeachment were limited to crimes, there would be very few acts by a president that would constitute impeachment. This position that only crimes or criminal actions by a president for impeachment is not consistent with the historical record or the debates at the time of the drafting of the Constitution. In fact, under the historical record for impeachment in the United States, most federal judges have only been accused of criminal acts in 30% of the cases. When the framers were drafting the Constitution for terms of impeachment, some proposed maladministration as a basis for impeachment. In fact, that term, maladministration, was used in many state constitutions as a basis for impeachment on the state level. The framers rejected maladministration because it was argued that it was too vague and it would allow Congress to wield power over the executive. In 1974, Congress authorized a congressional report on the proper basis for impeachment of a president under the Constitution. That report stated that high crimes and misdemeanor was a phrase that had been used by English parliaments for hundreds of years and that it had special historical meaning different from the ordinary definition of the term crimes and misdemeanors. Since approximately the 14th century, that phrase, high crimes and misdemeanors, has been used in English impeachment cases to charge officials with criminal and non-criminal offenses. George Mason proposed the term high crimes and misdemeanors as an alternative to maladministration. James Madison is quoted at the time of the debates of the drafting of the Constitution. Impeachment is indispensable for defending the community against the incapacity, negligence, or perfidy of the chief magistrate. Perfidy is defined as deceitfulness or untrustworthiness, certainly not a criminal standard of conduct. Ben Franklin is quoted as stating on impeachment, "It would be the best way, therefore, to provide in the Constitution for a regular punishment of the executive where his conduct should deserve it, and his honorable acquittal where he should unjustly be accused." The framers seem to view impeachment as a check on the executive by the legislature. Taken in total, the historical record, debates, and the framers had on this subject, coupled with the historic use of the term in English impeachment proceedings, it's apparent that the framers wanted to balance the power of Congress to hold the president in some way accountable and provide a mechanism if the House were to impeach and the Senate were able to vote a two-thirds majority to remove a president where he was found of guilty of treason, bribery, and other high crimes and misdemeanors, meaning acts that would be injurious to to the American people and the nation as a whole. It seems from the historical record in prior cases where a president's actions or inactions rise to the level of harming the nation or the Constitution of the United States, then if such leads to a impeachment proceeding and a 2/3 majority vote of the Senate, the president should be removed. With that, my friends, you have an idea of how a lawyer would consider the various issues in determining A, what the Constitution says, B, what the law means by terms like high crimes and misdemeanors, and C, then apply those standards against particular facts and circumstances of the issues today. Reasonable people may disagree. What conclusion do you draw? Do the Democrats in Congress that are pushing for impeachment have a good basis to impeach President Trump under Article 2, Section 4 of the Constitution? Can the House of Representatives make a finding that President Trump has committed acts that rise to the level of high crimes and misdemeanors? Would the Senate be likely to find for conviction or acquittal based upon your understanding of the law and your analysis of the facts? Keep in mind that two intelligent and reasonable people reviewing identical facts, applying identical rules of law, can end up with very different conclusions. After all, every time an appellate court overturns a trial court, what is happening is that the appellate court is drawing a different conclusion than the trial court. Even though in both cases you have experienced lawyers and experienced judges, somehow they draw different conclusions even though they're applying the same facts to the same law. Intelligent and reasonable people come to different conclusions when a state Supreme Court overturns a state appellate court, or when the U.S. Supreme Court overturns a lower federal court or state court decision. In the end, our goal here today is not to tell you what your conclusion should be or what the so-called correct conclusion is on the question of impeachment. Rather, our goal is to help you think like a lawyer, to help you reason through a difficult, complicated question in order for you to end up with a well-reasoned conclusion based upon your own analysis. Nothing black and white in the law, everything is gray. I hope you enjoyed our discussion today on how a lawyer looks at impeachment. Please leave your comments or compliments and objections in the comments below, and let us know if you'd like to see similar topics or if there's anything specifically you'd like to see on the DUFFLAW series, Think Like a Lawyer. Don't forget to subscribe to our channel and check out our videos on wills, trusts, litigation, and estate planning. We post new content twice a month, so stay tuned. Give us a thumbs up if you like our content, and make a suggestion in the comments below if there's something we can improve. Follow us on Twitter, Instagram, LinkedIn, and Facebook. Look forward to seeing you next time on DUFFLAW Digital. We hope you enjoyed our video today. Watch one of our upcoming videos. Be sure to hit the subscribe button, turn on the notifications so you know when we post new videos, and we look forward to seeing you again on DUFFLAW Digital.